take you back to the North Gauteng High Court, which is handing down judgment in the urgent application brought by Public Enterprises Minister Pravin Gordhan to have the Public Protector's remedial action on the SARS rogue unit set aside. We take you live to those proceedings.
Violation of the Constitution and the Executive Ethic Codes within 30 days of issuing of this report. The Speaker of the National Assembly is to, within 14 days of receipt of this report, refer Mr. Gordhan's violation of the Code of Ethical Conduct and disclosure of members' interests for Assembly and Permanent Council members to the Joint Committee on Ethics and Members' Interests for consideration in terms of the provisions of paragraph 10 of the Parliament Code of Ethics. The Minister of State Security is to, within 60 days of the issuing of this report, acting in line with Intelligence Services Amendment Act, implement in totality the OIGI report dated 31 October 2014. Within 30 days, ensure that all intelligence equipment utilized by the SARS intelligence unit is returned, audited, and placed into the custodian of the State Security Agency. Within 14 days of the issuing of this report, avail a declassified copy of the OIGI report dated 31 October 2014. The National Director of Public Prosecutions to note that I am aware that there are currently criminal proceedings underway against implicated former SARS officials, and that therefore effective steps should be taken to finalize the court process, as the matter has been remanded several times. The Commissioner of the South African Police Service to, within 60 days, investigate the criminal conduct of Messrs. Gordhan, Pillay, and other officials involved in the SARS intelligence unit for violation of Section 209 of the Constitution and Section 3 of the National Intelligence Act, including Mr. Magoshuli's conduct of lying under oath. Paragraph 9 of the report is also relevant and reads as follows. This relates to the monitoring, and I'm not going to read out the whole of paragraph 9. Will the granting of an interim interdict fail to promote the objects, spirit, and purport of the Constitution? An interlocutory interdict is granted pendente lite and designed to protect the rights of the complaining party, pending an application to establish the respective rights of the parties. It is aimed at ensuring, as far as reasonably possible, that the party that is ultimately successful will receive adequate and effective relief. Already in Piccoli versus President 2010-1 SA GNP at page 404 B to C, Duplessis J found, and I quote, "The court, considering whether to grant or refuse an interim interdict, must also bear in mind that the courts have a constitutional obligation to uphold the Constitution and to declare that any conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency." This test is formulated thus in National Treasury versus Opposition to Urban Tolling Alliance, 2012 in brackets 6, SA 223 CC at paragraph 45, and for ease of reference, I thereafter refer to this as the OTA decision. I quote, "It seems to me that it is unnecessary to fashion a new test for the grant of an interim interdict. The Settler-Goyele test, as adapted by case law, continues to be a handy and ready guide to the bench and practitioners alike in the grant of interdicts in busy magistrates' courts and high courts. However, now the test must be applied cognizant of the normative scheme and democratic principles that underpin our Constitution. This means that when a court considers whether to grant an interim interdict, it must do so in a way that promotes the objects, spirit of the Constitution. The Settler-Goyele test requires an applicant to establish 1, a prima facie right though open to some doubt, 2, a reasonable apprehension of irreparable and imminent harm to this right, C, the balance of convenience, and D, the applicant must have no other remedy. Applications for suspensions of mandatory orders pending reviews befit interim interdicts and are granted daily in busier high courts and magistrates' court. In fact, quite often, the PP's remedial action has been suspended with interim orders pending reviews of the PP's report. It was thus correctly conceded by counsel for the PP that normally these interim interdicts or orders are not opposed by the PP. In accordance with this normal practice, the President applied and expressed this practice in a letter to the PP dated 19 June 2019 and is set out as follows, and I quote, "In relation to your direction to submit my implementation plan, I reply as follows. I've noted the findings against Minister Gordhan in your report. I've noted, too, the assertions made by Minister Gordhan in his review application that your report falls to be reviewed and set aside because it is allegedly ultra vires section 6(9) of the Public Protector Act, issued by means of an unfair procedure and tainted by misdirections of law and fact. One of the legal complaints raised by Mr. Gordhan is that the direction that I take appropriate disciplinary action against him is vague and impossible to implement in the absence of an employment relationship between the President and myself. Having considered the findings against Minister Gordhan in your report and his challenges to those findings in his review application, I have concluded that it would be inappropriate to take disciplinary action against Mr. Gordhan at a time when not only is there a dispute pending before the High Court over the legality of the findings on which to base such disciplinary action, but also my alleged power to exercise such disciplinary action itself is legally contested by Mr. Gordhan in that dispute pending before the High Court. In the circumstances, my implementation plan in respect of the remedial actions set out in paragraph 7.1 of your report is the following. I have complied with the order to take note of the findings against Mr. Gordhan in your report. I have concluded that the process of taking appropriate disciplinary action against Mr. Gordhan would best be served by waiting until the legal processes of his review proceedings have clarified what disciplinary powers, if any, the Constitution allows me to exercise over Minister Gordhan beyond removing him from the Cabinet, and whether there are lawful grounds for the exercise of any such disciplinary powers. I intend, accordingly, to defer my decision on what disciplinary action, if any, to take against Minister Gordhan until final determination of his review application. I trust that you are satisfied with this implementation plan. I do not further read paragraph 8. In the PP's response dated 26 June 2019, she replies as follows. It is clear from the above that any advice to the effect that a review application stays the implementation of the remedial action is incorrect and is a sheer display of cluelessness on the person giving such advice. To this end, the President's letter is not only based on the wrong understanding of the law, but on a mere assurance by a third party that the President should not comply with my remedial action. The President's refusal to act on my remedial action is a failure on the President's part to uphold the Constitution. The Public Protector will therefore persist with the enforcement of the implementation of the remedial action to the parties directed against until such time that an interim order interdicting same is obtained. The President reacts to this letter on the 3rd of July 2019, setting out that he fears that the PP has misunderstood his letter of 19 June 2019 in that he has not refused to act on the PP's remedial action. He inter alia states, I believe that, applying the principle of the SCA judgment to the present situation, it is perfectly in keeping with public and legal policy for me not to undermine the legal process by determining that which the High Court has been called upon to decide in the dispute between Mr. Gordhan and yourself. As proceedings in the review applications unfold, the state of affairs in relation to appropriate action may well change. Should this happen, I will promptly notify you of any resultant changes to my implementation plan. In her further response, the PP in paragraph 9 of a letter dated 9 July 2019 sets out as follows. I fear that the Honourable President's persistence on willful non-compliance with my remedial action, which is based on the Honourable President's incorrect interpretation of the law, is not only ostensibly contemptuous of my office, but also borders on a breach of the Honourable President's constitutional duties as spelled out in the Constitution. I therefore plead with the Honourable President to avert the constitutional crisis alluded to above by taking heed of my advice and implementing the remedial action as set out in the report or obtaining a court interdict to stay the implementation pending the outcome of the review proceedings, or even causing the implicated and or affected public officials to do so. Such orders are sought and obtained daily in our courts in respect of review applications targeted at ordinary administrative action, let alone the remedial action of the Public Protector, which almost ranks as a court order in its binding effect. The question thus is, why does the PP not follow the normal practice as confirmed in her correspondence in this application, but labels it as extraordinary? It was submitted that the PP is opposing the granting of the application because of a duty to defend the independence, impartiality and dignity of the office of the PP, as well as her person. This flows from the averred vexatious, scandalous and irrelevant matter set out in the founding affidavit of Gordhan. It is also opposed on the basis that in terms of the Ota decision, this court will intrude in entering the exclusive terrain of another branch of government, will negate the separation of powers, and this matter is not the clearest of cases wherein an interim order should be granted. The EFF expanded hereon in that this application does not warrant judicial intrusion into the exclusive terrain of a Chapter 9 institution. Does Gordhan, as supported by the President, Pillay and Magashule, make out a prima facie right, even if it's open to some doubt? The first ground of review is that the PP has no jurisdiction in that she is barred to entertain the complaints under Section 6 in bracket 9. Section 6 in bracket 9 of the PP Act reads as follows. Except where the Public Protector in special circumstances within his or her discretion so permits, a complaint or matter referred to the Public Protector shall not be entertained unless it is reported to the Public Protector within 2 years of the occurrence of the incident or matter concerned. As the complaints relating to Gordhan flows from a meeting in 2010 and the establishment of an investigative unit in 2007, the Public Protector was not entitled to entertain these complaints. In the report, paragraph 3.5, the Public Protector regurgitates the factors setting out that could constitute special circumstances. Surprisingly, no factors are set out as to what she considered and why, in casu, it constituted special circumstances. In view of the provisions of this section and the fact that the complaints emanate from a decade ago, one would expect the Public Protector to set out why she had jurisdiction to entertain this claim. It is thus argued that on the report itself, without establishing jurisdiction, Gordhan has a prima facie right on review. In the Public Protector's answering affidavit, she boldly avers that all the review grounds are without merit and are denied. In argument, counsel for the PP did not address this jurisdiction issue at all. The EFF in the papers justify the jurisdiction of the PP in that Gordhan testified before the Nugent and Zondo commissions about this rogue unit, without a complaint about the events occurring many years ago. It was argued that this argument is unmeritorious and is rejected. The commissions had terms of reference, whereas the PP had to execute her duty in terms of the PP Act. In terms of Section 6 in bracket 9, the PP shall not entertain complaints after 2 years unless special circumstances exist. It is trite that the PP would have to identify these special circumstances, not the EFF. Gordhan, in a letter dated 27 March 2019, requested identification of the special circumstances. However, the PP never responded thereto. On 16 April 2019, Gordhan again requested the special circumstances to be identified. In the PP's response, she submitted that the special circumstances related to illegally acquired surveillance equipment, which was acquired at an astronomical cost, which is still being utilized to intercept communications, and therefore it constituted a special interest as public funds were still being used for illegal purposes. It was argued that even if this could constitute special circumstances, this is not forwarded as a special circumstance in the report and can in any event not sustain a special circumstance about the averred misleading of the Parliament by Gordhan. The EFF then proffers a special circumstance, not proffered by the PP. It is the public interest to an unlawful unit at SARS. The PP, not the EFF, must exercise the discretion. The PP has not forwarded the public interest as a special circumstance. On these arguments and submissions, Gordhan has established a prima facie right for the interdict to be granted. The finding that Gordhan violated the Executive Ethics Code in deliberately misleading the National Assembly. Paragraph 2.3 in brackets A of the Executive Ethics Code reads as follows. Members of the executive may not willfully mislead the legislator to which they are accountable. The review ground set up by Gordhan is that he did not willfully mislead the National Assembly. The PP found that Gordhan dishonestly concealed the fact that at the Ambani meeting there was a Gupta present. Gordhan sets out that until today he cannot recall that a Gupta was present, but his Chief of Staff informed him in preparation for his evidence at the Zondo Commission that there was a Gupta present at that meeting. He, without an independent recollection thereof, disclosed this fact to the Commission. The EFF submitted that it matters not that Gordhan may not have willfully misled the legislator. An innocent mistake is sufficient. This is, of course, contra the wording of paragraph 2.3.a of the Code specifying that it must be done willfully. On these facts, Gordhan has established a prima facie right. The establishment of the SARS investigative unit. In this ground of review, Gordhan submits the decision of the PP is irrational and fundamentally flawed. SARS has as its objective the efficient and effective collection of revenue and control over the import, export, manufacture, movement, storage, or use of certain goods. SARS has always had investigative and enforcement units that investigated inter alia tax evasion and illicit trade. It had a mandate to minimize the importation, exportation, and manufacturing of drugs, as well as the illegal harvesting of abalone and its supply, the illegal importation of second-hand vehicles, and the importation of counterfeit goods. It also had a mandate to curb the smuggling of cigarettes. Sections 4(a) to 4(d) of the Customs Act clothes SARS with wide investigative powers. To crack down on illicit trade and to combat organized crime, SARS needed to enhance its intelligence gathering. To this end, SARS and the National Intelligence Agency, hereinafter referred to as the NIA, entered into discussions to develop within NIA a capacity to support SARS investigating economic crimes with tax implications. An unsigned MOA followed due to the NIA losing its appetite to proceed with such a unit within the NIA. On 8 February 2007, Pillay recommended that SARS create a specialist internal capacity to focus on the illicit economy. On 13 February 2007, this proposal was approved by the Chief Officer for Corporate Services, Magashule. A unit to investigate and clamp down was established lawfully in terms of such objectives, mandate and legislation. This was the argument on behalf of Gordhan.